Now, more compelling talk radio 1320 WILS is live in Lansing with the Michigan Association of Broadcasters Excellence Award winner for Best Personality. This is the Capital City Recap with Michael Cohen.
Good evening, Thursday. Michael Cohen, producer Solomon Martin. First, it's not looking very good for this police officer in South Carolina, Michael Slager, the one who you see in the video shooting Walter Scott in the back. And some say that his lawyer, the one that just dropped him, is doing him no favors and is actually a horrible lawyer. Let's get some perspective from Brian Bouffard, a trial attorney, legal strategist, BouffardLaw.com. Also find him at JAGDefender.com, deals with military cases, civilian cases, does it all. Brian, great to have you here.
Michael, thanks.
I mean, just before we got on the air, I read this Bloomberg piece, really goes after this guy's lawyer. David Aylor is his name, who basically, this attorney dropped him the day the video came out, and then did an interview with a website talking about it. So I guess my first question to you is there any issue with a lawyer deciding to do that? This video comes out and he immediately drops the client.
Well, I'll start out by saying I have not seen the Bloomberg piece or the other article. I'm just aware that that's what's being reported. And I will tell you, a lawyer who takes a case and then all of a sudden sees bad evidence and then drops the client, that's pretty unconscionable. That's not something that I have ever done, and no lawyer who I respect that I know of has ever done that. Now, having said that, I will say that it is also possible that he met with his client. His client told him a long story before the lawyer saw the video. Then the lawyer sees the video, sees that the client has significantly lied to him. And under those circumstances, it may be more acceptable for a lawyer to terminate that representation.
Have you ever dropped a client?
I have never dropped a client for that reason or any other reason.
And so, because from what I understand, there under bar rules, you can drop a client if he, quote, uses you to act in a criminal or fraudulent manner, or, quote, if the client insists upon taking action that the lawyer considers repugnant.
Right, and that doesn't appear to be realistically in play at this stage of the game. That usually refers to issues such as, you're about to go to trial or you're in trial, and a client says, hey, I'm going to, I insist on testifying because I have a constitutional right to testify, right, but I'm going to lie when I get on the stand.
So is there something...
A lawyer can't let his client do that. Is
it unethical then for him to have seen the video and just having seen it personally felt that offended him personally and then to take that action as a lawyer?
Yeah, whether it's unethical on the disciplinary rules of South Carolina, I don't know. Uh-huh. What I can say is I personally think that at best it is extremely unprofessional if you're basically just running away from what is now becoming a tough case.
Right.
I mean, if you're taking a case, you got to take a case.
The article goes on to say that the lawyer's essentially now harmed Slager's interest by doing that. He's actually made it harder to defend him. Do you believe that to be the case?
No, I really don't believe that because whether he did it or not or why he did it is not something that would be relevant in front of a jury. Mm-hmm. And I'm quite certain that there will be another lawyer who will step up and who will take that case. And frankly, as repugnant as this video is, and it is repugnant, mm-hmm, if he asked me to represent him, I will certainly talk to him about doing that.
I'm talking to trial attorney Brian Bouffard. How do you go about defending a case like this, having seen the video? Well, first of all, is the video going to make it to trial, no question?
Oh, yes. That video is good evidence. I'm understanding now, although I have not seen it yet, but I understand that they're reporting now that there is also dash cam video from the officer's patrol car of the victim before the shooting. Mm-hmm. I'm very interested in taking a look at that. I just haven't seen that yet. But yeah, that's objective evidence.
And when you have a video that clear as to the shooting itself, what kind of an angle can you take to actually defend that?
From my vantage point sitting here, knowing, having not talked with this officer, not knowing anything other than what's on the video, it's difficult for me to imagine how they're going to try to put forth a self-defense claim. Originally the officer said, clearly lying about it, well, he took my taser and I felt threatened and those kind of things. But the video completely, in my mind, disproves that. So I would start with as I always do, I show the evidence to my clients and we talk about it.
And is this something where you'd likely pursue some kind of a plea agreement then?
If a plea agreement is even offered, this is a case that if I were a prosecutor, and I'm not beholden to law enforcement, and I wasn't even as a prosecutor, I would be chomping at the bit to try this case.
And this would be a first-degree murder case?
Well, I don't know the degrees of murder in South Carolina. I'm not a South Carolina lawyer, but certainly it would be a high-level felony murder case, and possibly with the official oppression involved, and that he was doing it under the color of law. That might create other issues that are going to be problematic for this officer.
Okay, so is the officer's state of mind, could that play a factor in affecting the jury, saying, look, the officer may have had some kind of physical altercation before the shooting?
That's possible. Would that justify what he did, though? I would say the answer is no. I mean, let's take a moment and let's assume the worst. Let's assume, without knowing this, let's assume that, he pulls this victim over. The victim is incredibly upset, violent, pushes the officer, hits the officer. I mean, whatever happens at the beginning, the video shows him running away. And when he runs away, he is no longer a threat. And for that officer to say, I felt threatened at the time I was shooting at him, that seems to be fairly ridiculous when you take a look at what we've now all seen.
And what does that leave as a defense then?
That's a real good question. I don't know if they're, maybe insanity defense.
You go in and you have to acknowledge that he did fire the weapon, right? You have to acknowledge what's on the video. You said an insanity defense, potentially?
You never know. I mean, I hate to go that far off the rails speculating about something that just happened, but I can definitely tell you from a legal perspective, this is going to be an extremely challenging case for the defense because, as I stand here right now, I can't imagine a good argument at this point that would justify what we've all seen on that video. That is cold-blooded, back-shooting murder.
In terms of a lawyer that would take this, is there a difficulty for a lawyer, for yourself, to consider taking a case when you see a video like this?
It depends on what you mean by difficulty. I mean, is it challenging? Absolutely.
Well, I mean, do you kind of waver on whether you want to defend somebody who's done this?
I think that is certainly something that can enter the mind of a lawyer. I mean, there are certain cases that some lawyers won't take for ideological or moral reasons, child pornography, cases like that. I am of the belief that everybody deserves a defense. The devil himself deserves a defense because that's the way our system is built, and if the devil doesn't get a defense, then you and I don't get a defense.
In terms of pleas, if you have a case where you really feel the evidence is overwhelming against you, what would you attempt as a lawyer to plea in a case like this?
Those are negotiations that would really go back and forth with the officer, with the prosecutor. The problem is that a negotiation really only works well if both sides have some kind of leverage. If the evidence is arguable that they could prove it, but there are significant problems with it for the state, then those are the kind of cases where plea agreements can often be reached. But in a case like this, like I said, if I'm the prosecutor, leaving political concerns aside, which I'm sure are going to be many in this case, but just from an advocacy standpoint, like I said, I would be thrilled to try this case.
Okay, which means that you're not in any way going to look to, not even to potentially avoid the trial process. You want to go through it all?
As a prosecutor, I would tend to say yes. As a defense attorney, I would probably be looking for a plea based on what I've seen.
Okay, and a plea. So there'd be a first degree, second degree. That could you essentially plead maybe a second degree murder as a compromise, that kind of a thing?
But that's often possible. Again, I don't know the specifics of South Carolina criminal law, but sure, you can plead to more or less time or more or less punishment. You could plead to more or less of a charge that would also tend to reduce the punishment range. Probation versus pen time. All those kind of questions would be in play. Another problem with this case appears to be that this officer was cited for excessive force about 3 years ago. So his record is going to come into play too. And if I'm the family of this poor man, I'm suing the pants off of the police department in the city as well.
His behavior after the shooting, the fact that he clearly didn't appear to, he handcuffed the man when he was on the ground and didn't appear to be concerned about his welfare. Does that play into how the outcome might be for the jury on this?
Not only does that play into it, but I think more specifically the fact that it appears that he tried to plant evidence so that he could lie and say that this man stole his taser. The fact that this officer clearly didn't know he was being videotaped, video recorded, and had that cameraman not been there, he would have made that claim. He took my taser, I had to shoot him, and he would be believed because that tends to be what juries do. But as time goes by and as we see all these cases of police brutality, Ferguson and Eric Garner and now this, I am hoping that juries are going to become a lot more intelligent about how police officers can sometimes be.
Brian Bouffard, trial attorney, legal strategist. It's bouffardlaw.com. Also, jagdefender.com. We'll see who his next lawyer is and how he'll handle the case. It sounds like, so in a sense, though, you'd have a case potentially where you'd walk in thinking, well, we probably won't win this one. Is that part of the deal?
Well, every time you take a case, you've got a sense of what the evidence is, and sometimes the evidence is very overwhelming against your client. And sometimes, realistically, even though a defense lawyer should always, first and foremost, look to see can the government prove this case, very often the government can. And so sometimes you're having a very candid discussion with your client about likely outcomes and what that client wants to do. And oftentimes a lot of cases come down to trying to get the most appropriate punishment for your client if guilt is overwhelming.
Yeah, that's what it's going to be. Brian Bouffard again. Thanks, Brian.
Thank you, Michael. Take care.